Hey, what's up, Doc? Good.
I wasn't here yesterday, so I may have missed some of this, but in the process of getting all of this going, you filed your trial, you filed your trials and your motions and everything. Will there be interrogatories? Would Bill have been questioned as an interrogatory prior to going into an actual court hearing?
Okay, you can use uniform and non-uniform interrogatories and depositions. Right now, we're primarily doing requests for admissions, and they don't even what they come back is just completely non-responsive. It's almost funny. But yeah, if you get that far, sure, you're going to do interrogatories. You're probably going to do a deposition, hence the subpoenas and stuff. Yes. I'm a firm believer in depositions. Yes.
And then will the bank have their own witness that they'll list and want to be, you want to interrogate him and depose him?
Yes, but you're not really concerned with that. What you're concerned with is who did what in the pleadings and who did what with the bank. I'm not concerned who their witnesses really are. I'm concerned with who at the bank said what. I don't really care what their experts say. It's going to be too easy to rebut. So somebody along the line signed stuff to get all of their fraud committed. That's why I want a subpoena. Because most of the time, people commit fraud. If nobody's going to know who they are, they're not likely to take the stand. And that means everything goes on hold, and after being on hold for too long, you can get rid of everything.
So then you can make a motion to dismiss based on non-action by the bank and declare.
Well, it wouldn't be a motion to dismiss. It'd be declaratory judgment because you're bringing the action. And when you get the declaratory judgment, that would undo the non-judicial proceeding. That'd be the order from the court. Okay, one more question. Go ahead.
I just want to make a statement that if they're not a party to the action, if they're not a party to the action, you have to depose them. You can't serve them with interrogatories.
What's that? I'm sorry.
If they're not a party to the action, like your expert witness, you have to depose them, not serve them with interrogatories.
Yes, but who are we talking about that's not a party to the action? He's talking about their witnesses. I'm not talking about their witnesses. I'm talking about them. They are a party to the action.
Yes, but he
Yeah.
wanted, he said, like with Bill, could they serve him with interrogatories? So I just made the statement, they would have to depose
Oh, I
him.
see what you're saying. Yeah, they'd serve her with the interrogatories. They'd depose him. Do the banks ever try and depose you?
No.
They're not going to depose him.
No.
Okay, now we're going to get a little funky. You guys switch.
Oh, shit.
Yeah. Okay, and the reason we're doing this is just my abusive nature. But, no, because she may be actually, I don't think she's going to wind up in court. I really don't. But I think she might wind up in a hearing. The thing is, she keeps on trying to go, and they keep on kicking her out of the courthouse. What I kind of want to do here, Bill, you've got an awful lot of experience.
Yeah.
Okay, so you know what to do as far as lead her through this. And then I'll come back at the bank on what I've seen, how I'm going to try and destroy her. Now, you've seen enough of this. You best not be answering questions wrong at this point.
Who am I? Am I the homeowner?
You're Cindy Cantrell, and you're in a friggin' hearing because they're trying to take your house, and they're
Okay.
trying to stop them.
All right. I just want to make sure I wasn't the expert because I didn't want to be the expert.
Is Bill the
You should know who you are. Did we get coffee?
Hey, would you grab me water?
We didn't get coffee?
Oh, okay.
Oh, thank you, Tim. Okay, so
Am I representing her?
yes, you're her attorney,
Okay.
and so you're gonna kind of lead her. I don't know. Would you rather be on the other side?
No, I'm fine with it. I know
Okay.
exactly what to
Eh,
say.
Okay.
Excellent.
And they're the plaintiff, you're the defendant, correct?
Yes, I'm the bank.
Okay.
Now, in her case, she's probably not going to have an attorney. Okay, she's going to be her own attorney.
So you don't want Bill to be, since he knows what the other side usually says? You want to be
Okay.
that person? Okay.
First of all, I want you to learn, and I want them to learn. A lot of these people will have an attorney like the Jill Slicker thing, or just hire a mouthpiece to come in and do a lot of the litigation in the courtroom. And I'm not against that at all. So that's who Bill's going to play.
Okay.
He's just been somewhat involved in the case. So he's going to kind of lead you through that, and then I'm going to try and, just like what the bank did with the Slicker case, cause her to, what I'm trying to establish here is if you get this far, you're going to take the stand. Chances are, if you've done good up until now, you will destroy your own case when you get right there. Happens almost every time. Okay? So you better be able, yes? No, this is not a criminal case. He's her attorney, but it's
Yeah.
not a criminal.
Yeah,
Yes.
I'm a
There are no
litigant.
public defenders in civil.
We're gonna have opening statements, or are we just gonna move
No,
forward?
we're just going to move forward with it.
Okay.
What you've got to do, what I'm trying to show you is you can make very simple statements that are just wrong enough to screw you. One of the statements in the Slicker case was the attorney asked her, when did you get the loan, or did you get the full loan? She should have just said, no, I never got the loan. They still haven't given me the loan. That's much stronger. Now we got a whole argument that they aren't going to want to explain. So let's just, we've got about 15 minutes. Let's go ahead and we're going to play this one out. So you're the plaintiff, so it's your client and your witness.
Okay. And you want me to answer?
Thank you, Mr. Wiggin. Just take her down, the primrose path. No, that's fine. Thank you. What you've seen the plaintiff's attorneys do with their clients.
Okay. Ms. Cantrell, the day you took the loan out, you took it out with a company called Homecomings Financial Network Incorporated?
No, I didn't get a loan.
No, that's not okay.
No, you're
Remember,
not
this
supposed
is
to tell me
your
that.
attorney.
I know.
I never
but
told
my
you to
attorney's
say that.
screwing me.
No, you're not. The day you took a loan, and it would be more.
You just
who
killed
did you
my
try to
case and
get-
you owe me $10,000.
Who did you try to get the loan from?
I attempted to get a loan from Homecomings Financial Network, Inc. on May 31st, 2006.
Okay. And on May 31st, 2006, did you sign what is Exhibit A with the courts, an adjustable rate note?
Not having the original, I can't validate that that is my signature, but I did sign a document that appears to look very similar to that one.
Okay. And on May 31st, 2006, you took a loan out for $448,000. Did you get any cash back?
I attempted to take a loan out, and no, I do not recall receiving anything.
Okay. And this was a purchase transaction?
This was supposed to be a refinance.
Okay. And again, as I asked you earlier, was this a cash out or was just an attempt to lower your payment?
If I remember correctly, it was to combine two prior liens that I had into one new lien. That's my understanding.
So in looking at the document that I have in front of me here, it looks like you have what's called an adjustable rate loan with an MTA index that would reflect a very low interest rate. And I believe that interest rate that you are trying to obtain would be in the neighborhood of between 1% and 2%?
Correct.
Okay. And the reason that you're having problems now and you haven't paid it is because the interest rate has gone up considerably. Is that not true?
That is correct.
And the reason that it's gone up considerably is the documents that you signed, were you aware of the type of loan that you were getting?
No, I was not.
Were you aware that your interest rate could be greater than 10%?
Absolutely not.
Okay. Were you also aware at the time that you got this loan that you would be making a payment and it would not be covering the principal and the interest on the loan?
No, I was not aware.
Objection, Your Honor. The plaintiff did sign the documents. All that information is in the documents.
Ms. Cantrell, did you understand when you signed your loan documents a disclaimer that explained how this note and this loan would work?
First of all, I do not understand anything, because to understand means they know that I'm okay with them investing in my
Don't
team.
give them a definition of understand.
Okay. I don't understand anything, and I didn't understand that, that clause in that document.
Okay. And it is the understanding of the court that when you sign these documents, again, I want to point out, you did not know that your loan could go up to 10%?
Absolutely not. That was never explained to me.
Okay. And the reason that you...
Objection, Your Honor. It was explained. It's laid out in the documents very succinctly.
Have you ever tried to get a modification on this loan, Ms. Cantrell?
Yes, I did.
You want me-
And how long
do
did that
something.
process take?
It was about 3 months, I believe.
And did you ever get a notice either approving or denying?
Yes, I did.
And what was that notice, and what did that notice say?
Well, the notice said that it denied me, saying that I did not qualify or something for it. However, an agent for Bank of America told me on the phone that the reason that I didn't qualify was because of a mortgage pooling and servicing agreement that was in place that would not allow me to modify my loan.
Were you aware at the time when you had contacted Bank of America that when you did contact him that they had made reference to any such agreement between Bank of America and any unknown interested party?
Objection, Your Honor. The plaintiff accepted the loss of rights for the banks to handle the note and the deed of trust in whatever manner they saw fit. That plaintiff does not have the right now to question how the bank handled the note or the deed of trust.
Sustained from the question, stricken from the record. Please restate.
Were you aware that you would be making payments to an unknown entity other than...
Objection, Your Honor.
Homecoming's
Relevance. It
Financial
doesn't
Network.
matter who she makes the payments to, as long as she makes the payments in accordance with who the bank tells her to pay.
Mr. McCaffrey, we're going to have to refrain from this line of questioning.
Okay. Have you ever made a payment to Homecoming's Financial Network?
Yes.
How many payments did you make?
34.
And on the 35th payment, were you ever noticed to start making your payments to Bank of America?
I received some type of document that was from, I believe it was from BAC Home Loan Servicing, that said that I needed to start making payments to Bank of America.
Okay. Are you familiar with a bank by the name of the Bank of New York, Mellon Bank?
I've heard of them.
Would it surprise you if your payments were going to the Bank of New York, Mellon Bank, instead of
Objection,
Bank of
relevance,
America?
Your Honor. Goes to foundation. There's no, it's not a point in contention. It doesn't matter who is supposed to receive the
Mr.
payments.
McCaffrey, I'd like to know where you're going with this. I'd like you to get to the point. This is dragging on, and I'm going to sustain you from continuing with this line of questioning. Please continue and make it brief.
What I'm trying to point out is that Ms. Cantrell took a loan out.
Objection, Your Honor. This is not opening statements. He's testifying, not questioning the witness.
We're quite aware of the loan, Mr. McCaffrey. Can you get to the point?
Ms. Cantrell took a loan out from Homecoming's Financial Network and was never notified that the actual entity that owns this loan is the Bank of New York, Mellon.